And it's based on 1 week of testing, which you probably should be doing on your own anyways before you go to them, but a lot of people don't, which is why the more unknowns means they can get more leverage. It's also dependent on what kind of company do you want to grow up and be. If you want to be a lifestyle game studio, then publishing is great. You want to make games forever, awesome. If you actually want to grow for that big scalable hit, you want to exit someday, then don't take a publishing deal, or take it as a one-time learning experience and then move on to making your own games after that.
That's excellent points. And the places where I do encourage or don't have any issues with publishing is maybe you got a title on iOS and you don't have the bandwidth or the capacity to port it over to Android. You can just do a publishing deal with someone on Android. It makes absolute sense. Maybe geographically, give someone a publishing deal in Asia or Europe. So those are situations that make sense. And finally, this game just isn't going and you want to do a new game, you're basically just selling it. So you monetize it through the publishing deal, take whatever money you get and put into the new title. And that new IP isn't subject to the publishing.
So I agree with most of that. For the Android case, there are a number of newer distribution companies, especially Israeli ones. Hint, hint. Go look it up. That want case studies of how well their distribution platforms work. So if you are, an entrepreneur is all about hustling, right? If you can hustle well and negotiate those types of deals, it makes sense to go to one of those guys and say, listen, I'll give you this much data ID identified. You can use me as a case study for your future clients. Give me X number of installs. And if from those installs you can't prove out that the game works, then kill the game. Don't spend too much time on that if it's not monetizing enough for you to keep getting more users onto it.
Any questions on investment, publishing, any stuff we've covered so far? We're going to switch over to some more kind of hardcore legal issues, I guess, and kind of really get into the fun
I have
stuff.
a question. So just in your opinion, it's probably better to get funding for your studio than go to publishing?
Absolutely.
Yeah.
All things being equal, yeah.
Contrasting now to, say, a couple years ago, what's the temperature for platform plays, for middleware SDKs and so on? My perception is that the interest has gone down because everyone lost a lot of money on Zynga, but is that?
So if I could take a crack at that, I think it depends on, so Zynga wasn't a platform play, right? Content play. So, but I think it depends on
it's
what
a games
space.
Play, which
what space. So actually, I see a lot more attention, at least in our portfolio and the investors that come into YetiZen, and we have a couple hundred of them, to platform plays, right? But it depends on the type of platform play. So if you were actually trying to do a platform play in and around distribution, the perception is there's so many other competitors out there, and a lot of those competitors didn't IPO, didn't have a big outcome, right? So that may not, again, it becomes, is this going to be big enough for a VC investment? Probably not, right? But if there's something new, like we have this thing called Galaxy that allows you to make your mobile into a console, play on any TV, and plug in with existing controllers you own. That's something that's interesting. It's something that's opening a brave new, entirely different market. Not too many direct competitors out there, maybe a couple of different people who think about it differently, but there's just not that much competition. But distribution, it ends up being like, whoa, there's 45 different distribution options out there. How are you going to be any unique, and how are you actually going to be able to make this at scale of, say, a Chartboost, who can just go to his partners and say, hey, plug into this new feature, right? So it depends very much on what it is, but platforms, I think, is more understandable to most investors.
So, again, we want to make this interactive. Here's just some of the legal issues we may touch on here tonight, and we may jump around a little bit depending on how some of these issues come up. So there's a whole host of compliance or kind of regulatory type issues. Privacy and COP obviously is kind of one. With virtual currency, and we're going to cover that in the third event of the series, but many of you may be aware that FinCEN, which is one of the federal agencies that deals with anti-money laundering and financial regulatory issues, issued guidance in, I think it was March of this year, addressing how the existing regulatory scheme under the Bank Secrecy Act and money transmitter laws applies to virtual currency, both centralized virtual currencies, that are those that are issued by, let's say, a game developer or publisher, and decentralized currencies like Bitcoin. So we'll cover that more in detail in the third one. And then the contest, sweepstakes, and gambling, we've seen a lot of that, and we're going to cover that in the gamification. So one of the other kind of big areas for mobile apps and games, of course, is IP protection and some of the IP issues that go along with that. And in addition to protection, as far as registrations and things like that, There's other things like DMCA, which we'll touch on a little bit, particularly in connection with Chris's company. Anytime you have user-generated content, there's always a risk that some of the content will be infringing other people's copyrights, and that's not really user-generated, but rather user-uploaded from some third-party source. The DMCA, which we'll talk about, can be protection for that. And then one of the things that we think gets very little attention that should get more, because it can actually protect you in many ways, and that is terms of service and EULAs. It's an opportunity kind of for you to dictate the rules between you and your end users, and to provide protections for yourself, provided you do it the right way and you're clear. So that's just kind of maybe some of the issues, and there's a few other kind of isolated issues we'll talk about as well. I think one of the things that was telling, question, yeah?
In that, I think it's very interesting that the content issue associated with user-generated content, IP related to that. But Chris also highlighted something that, until he said it, I hadn't thought about the complexities associated with it, where a player is actually creating content, and there may be other players that are creating derivatives of that content. And from a IP perspective, or maybe it's all in the EULA as far as the terms and conditions of somebody going in the environment, but can you also touch upon that at some point? I think that's an interesting
I'll get it at a high level right now. So it is really interesting. So I mean, IP is complex enough when you deal with a single creator of the IP. In a situation where there's joint development or collaboration, you get into just thornier issues with co-ownership. And so when you look at the issues, it really kind of breaks down into like two high-level categories with respect to that. One is you have the existing copyright laws, which generally are going to dictate ownership of individual works and derivative works. So derivative works being something that builds on something that was done before. And there's the kind of the regulatory scheme around that. And generally, whoever creates something, absent an agreement, or if it's work for hire in limited circumstances, whoever creates it is going to own it, own what they created. The way derivative works plays out is that if you add to something that I created, there's two issues. One is, did you have a right to modify what I did? Right? As a copyright owner for my original creation, I can prevent you from making derivative works. But if it's in an authorized situation, where that's part of the model, then you're permitted to do it, and so your creating a derivative work would not be unlawful. There are other circumstances under fair use and others where derivative work may be appropriate as well, but that gets kind of deeper into this. But assuming you do have rights to modify what I made or add to it, and you come up with some additional creation, then what you have is, again, absent an agreement, you own the derivative work. So essentially, if there's a work that combines, part A and part B, and I'm the copyright owner for part A, and you created the combination of A and B, you would own the copyright to A plus B as a whole, but not to my part separately. So, and again, assuming you had a right to use my part in the first place. So at a real high level, that's how it works. Now, as we'll get into, if through the terms of service or other agreement, there's a change in those circumstances, you could require players to assign their rights. So it could be joint, the whole thing could be jointly owned, or in some cases, the platform. You may, by using a platform to create IP, the platform may require that to post content to the site, you grant ownership. There's issues with doing that. More often you will license it so that the platform can use it, and the users can use it, and grant the right to make derivative works in this case. So there's a lot that goes into those decisions as far as the business model, but that's got a high level, that's kind of the law around that.
Is that what you've done, or are you hoping that the kids just won't sue you?
Yeah, that was a great explanation.
As far as your model, right? So how do you deal with the IP issues on your platform?
So we use the Creative Commons approach, so that we're enabling them to make derivatives, but they're unable to monetize those derivatives. I think it gets a little bit hairy with what you mentioned before, is when the kids are able to replicate something which is owned by an IP holder outside of the game. So it's not uncommon for kids to build a character from Minecraft inside our game, for example. And what do you do then? Because we don't want to have ownership of that, because then we're breaking that.
Right, well, and they can't assign to you what they don't own either, which
Yeah.
is another issue.
Yeah, so that's when the terms of service come in.
Right. So when you, there's different forms of the Creative Commons license. So what are the, which, do you know which form it is of the Creative Commons?
Not off the top of my head, but it's the one where you can do pretty much anything apart from monetize
Okay.
our
So they can use other people's content and build on it and.
no, so there's also the moderation, which is an expense for the company. So we don't let them upload their voice, for example, because they could be swearing. We don't want to poison our community through that kind of creativity. So everything we give them needs to be moderated very cost effectively.
So one other thing while we're on copyright, I mentioned the DMCA, and so when you have a situation such as Chris's company where you have user-generated content, ideally it's user-generated, but as I mentioned earlier, sometimes it's just user-uploaded content, and it's actually third-party content that the user is uploading. That creates potential liability for you as the platform owner. There's different ways of dealing with that. One of the most effective ways to deal with that is what's referred to as the Digital Millennium Copyright Act, or the DMCA. And the DMCA is a very, very powerful tool for any online service provider. What the theory behind it is that as the internet started, kind of emerging, they kind of realized quickly that one of the powers of the internet is for people to share information with others, and that there would be people posting content to other people's sites. And the issue around copyright was who should bear the burden of policing copyright infringement. And the regulatory decision was to put the burden primarily on the copyright owners, not the platform providers, subject to certain limitations. And so the way the DMCA works basically is this. If you're an online service provider, whether it's a game, and any online service, it's defined very broadly. If you register a DMCA agent with the Copyright Office and put notice on your site of who that registered DMCA agent is, subject to a few other exceptions which I'll mention, then if a user posts content to your site and it's infringing someone else's copyright, then that copyright owner has the burden of policing that and can send a notice to you through your registered DMCA agent saying, this is my copyrighted work, take it down from your site. If, as the online service provider, you comply, you take the content down, then you won't be liable. There's a few other steps I'll mention in a second. But you also have to give notice to the entity that posted the content, that you got a DMCA takedown notice. And if they object and say, no, this is not third-party copyright, this is my own creation, or if they believe an exception to copyright infringement exists under fair use or any of the other exceptions that might apply, then they can challenge that. You can put it back up, and it's up to the two of them to fight it out. One of the things that's also important and a requirement to get the DMCA protection that many people overlook is you have to have what's called a policy to terminate repeat infringers. So under the DMCA, they make that an explicit requirement. And so what that means is that if the same user is posting content on multiple occasions, and there's not a hard and fast number, there's been a couple of cases where Google, for example, has their policy, if the same user gets 3 notices, you terminate their account. But that number's not magical. You have to actually terminate their account, though, if they're caught several times doing this. This is an incredibly powerful tool. It's relatively cheap to get this protection. It's relatively easy to administer. And just as an example, YouTube, as we all know, there's a lot of infringing content on YouTube. There's a lot of user-generated content. There's also a lot of TV shows and movies and everything else that we all enjoy watching for free. But the content owners, Viacom and others, don't really take too kindly to that because it really impacts their market. Viacom sued YouTube for $1 billion for damages for all the allegedly infringing content on the site. And the case has kind of gone through various iterations, but in the very initial decision, the federal court decided on summary judgment, didn't even go to trial. The federal judge basically said, as a matter of law, YouTube's complied with the steps required to get DMCA protection. As a matter of law, I find no damages, no liability. The case has been on appeal, and there's been some other issues that have kind of gone through, but still to this day, there's been no liability found because they complied with the DMCA. So if you are in involved in a company where you're dealing with user-generated content, I strongly suggest that you take advantage of the DMCA. Question?
The subtle point that you made that I've heard other companies make mistakes in is it is so easy to register that often the companies almost feel like, okay, I registered, I'm protected. And there's a number of procedural requirements for you to get that protection that you have to maintain. And if you don't, then your protection falls away.
Right. It doesn't mean you're necessarily liable. I mean, the copyright owner still has to prove copyright infringement, and they have to prove that there's no, you could, if they prove infringement, you can always rely on a defense. So it doesn't mean that if you don't have DMCA protection that you're automatically liable, but it's going to take away a very powerful defense if you don't comply. And as was stated, you have to do all the things required by the DMCA, including the steps that I laid out. One other kind of flip side, if you're a content owner and you have content and you think someone is posting it to a third-party site, you can do a DMCA takedown notice. One of the things I'll tell you that is kind of a potential issue that a lot of people aren't aware of is that if you do an improper DMCA notice as a content owner, you create a liability for yourself. So what's an improper DMCA notice? So there's requirements as far as what has to go into the notice as far as the specific content and where it can be found, etc. But the courts have actually said you have to consider whether or not the use is fair use or otherwise exempt from copyright infringement. So one of the things that we've seen a lot of copyright owners start using, because it's obviously very hard to police this, there's a number of tools out there where they've kind of automated the process of doing, it's like kind of a digital fingerprinting. They basically will scour the net and find examples of where either TV shows or songs or other content shows up, and they automatically generate notices and send them to those sites. The problem with that, and this is where some of the issues would come in, is if you don't actually do a consideration of whether there actually is an infringement. There have been situations where the content was actually lawfully posted and authorized by the content owner. That didn't get picked up through these automated tools. And in other situations, there was a fair use. So fair use, there's a whole range of issues for fair use, but if you're using a copyrighted work in a number of ways, whether it's for education or news reporting or something else that is a fair use of it under the court's test, you can be exempt from copyright infringement. Chris, how have you dealt with this issue? Bring it back from a practical business perspective.
Yeah, so working with the rights of famous tracks, we've just kind of tested the water, and it's really just comes down to the manager and the publisher's perspective. And I think really until you're a massive game with millions of dollars of income, people are happy to let you see where the rights go and then kind of rein them in when they see there's money being made.
Right. That's a little bit of the roulette model, right? So you can, there's a lot of content out there that's infringing that's being used, and as the content owners can't go after everybody. So it's as you're small, it's probably less of an issue. But as you get bigger and scale more, people care more about you using their content.
And the same goes for content licensing deals. So one of our mentors is Kai Huang, who was one of the founders of Guitar Hero. And he said that when their sales were smaller, the licensing deals they got were really awesome, right? For a lot of the music games, but then for a lot of the music tracks that they were licensing. But then the moment they started making more money, all those partners wanted to actually renegotiate those deals to be getting more money from off the table. So that tends to be something that I think all startups need to remember, is that if you're building your business off of the backs of someone else's created content, what will that mean in the future when you're actually going to be bigger? Or do you want to diversify and hedge your bets? Like maybe if you have, like I think for Chris is a great example, music is just one part of that MMO, right? So they're always going to have other experiences for the user and have a large user base. So should the music guys actually want to negotiate, you still have a lot more to say, hey, maybe not, because it doesn't make sense overall with the rest of my business model. And if you're large enough and there's enough value for them, they might come and meet you somewhere halfway. But if you're dependent only on that person or that sort of company that you're doing these licensing deals with, and that's the only part of your business, and then you're tough luck. You will kind of have to give them what they want. So.
Just in terms of mobile gaming, I'm not sure how you would do that automated sniffing to find the content, so it's probably still the Wild Wild West in mobile games.
Yes. So we're going to get into privacy here. So I thought this was interesting. So about 2 years ago, at one of the American Bar Association speeches, the FTC commissioner stated that you'll see more enforcements on mobile apps, and I think that's been very true. We've seen over the last couple of years much greater scrutiny by various federal agencies of mobile apps, and one of the areas where we've seen a lot of this is in privacy. And I think what's interesting when you deal with the kind of the regulatory issues, one of the challenges is that ideally you'd like to have these black and white lines, right? And you'd like to have a clear line in the middle saying if you're to this side you're legal, if you're to this side it's illegal. Unfortunately, even like the FTC, their guidelines are a bit fuzzy and blurry, and there's not these clear-cut lines, and they've been kind of hesitant to give too much guidance because they want to see how things develop. They're kind of looking at the industry and looking at industry best practices, and while they have certain statements they've made of things about you have to have clear and conspicuous disclosure or terms like that, it doesn't tell you exactly what that means, particularly when you get to mobile. I want to talk to Chris about that in a second on the privacy. But so dealing with regulatory issues is a balancing act. And while you ideally would like to have this, kind of this kind of clear line, what really happens is there's black and there's white, and then there's a lot of gray in the middle. And the white is legal, the black you go to jail, and there's a whole lot of gray in the middle. So when it comes to dealing with these issues, both from a business perspective, it's a question of how much risk are you willing to assume. And as a startup, we generally tend to see people willing to take more risk because if you're small, you're probably not under the regulatory scrutiny as much. Although there have been some small companies that have gotten zapped pretty early on too, so I think you have to be careful with that. But certainly as companies get more mature, you definitely need to get closer to the white side of that gray.
Isn't some of that? Oh, sorry. Isn't some of that also like if they're getting slapped early on, it's because the FTC wants to make an example out of them as deterrent. So is that and to what, is there some guidance you can give all of us about what some of those areas might be where they might be looking for folks to make examples out of?
Yeah. So, there's a number, but that's exactly right. I think that the task of the FTC in trying to enforce privacy, there's tens of thousands of apps, and there's just, it's increasing in games and everything else. To my knowledge, they don't sit there and review every one of these. But I can tell you that the clearest and easiest way to make yourself a target, whether you're big or small, is to piss off consumers, right? So if the FTC gets complaints from consumers, they will look at that, and they have been vigilant about that, whether you're big or small. So the single best advice I can give you is don't do that. And so what does that mean? It means, be upfront about what you're doing. We have clients, won't name them, who, when you advise them on privacy issues, you say, okay, what kind of data are you collecting? What are you doing with it? Well, we're doing this and this, and we start doing the disclosure, but we don't want to tell consumers we're doing this. Like, stop right there. If you're doing something and you don't want to tell consumers, think about that for a second, because people will find out what you're doing and what's going to happen when they do, right? The FTC is going to come knocking. So, part of the balancing there is to just be clear and be upfront. And to have a good business model, you don't have to hide what you're doing. I think that's just the simple, practical advice.
I would imagine a corollary to that is what you see with Facebook, which is they're changing it every 10 minutes, and that'll piss people off too.
Right. Yeah, and they certainly have drawn a lot of attention. They've drawn a lot of complaints, but they push the envelope. They're at the cutting edge of a lot of things, and I think that the FTC has tried to provide more guidance, and even when you look at certain things, and I don't want to kind of comment negatively about Facebook, but in some respects there was concerns that even when they went to more user control and they gave you the ability to control more aspects of your privacy settings, people still complained because there was too many settings, or people didn't know that certain things were defaulted to it's going to be disclosed as opposed to not disclosed. So even as you make improvements, right? It's important to think clearly from the consumer's perspective is, what's going to hurt people and what's, kind of what's not. And there's always a tension. This is true of all these issues, a tension between the legal issues and the business side, right? As a business, you want to maximize your opportunities. You want to do all those kind of things, make more money, and of course, that's why everyone's in business to do that for the most part. And the legal side, if you do everything you can to be legally safe, you're not going to be in business. So it's a question of finding that balance. And so, do you do opt-ins or opt-outs, right? The FTC suggests strongly that you do opt-in. So if you're going to use data and you're giving people an option, you have to affirmatively have them understand. Notice and consent are two of the big words. Notice being clear and conspicuous, and consent means the user has to consent to it. And so people have tested that with, okay, is consent sufficient when you have someone opted in and they don't opt out? Is that consent? And depending on the notice and disclosure, it may or may not be. So, so there's been a whole host of cases, and I think one of the ones I'll talk about, just one case study real quick, and we'll go to Chris. Path, right? So I think Path committed a couple of sins, right? And I think it's kind of they paid an $800 million or $800,000 fine. Sorry. And they did two things. One was they were collecting information from kids under 13. It was like 3,000 incidences that were documented, and that's just a no-no. If you're dealing with kids, you have to deal with COPPA, and the level of protection is very high. The other thing they did, and this is an example of, eventually this stuff's going to come out in the wash, is that they gave people an option to, you could add friends to, and connect through the app, through the service by either connecting through Facebook, by giving access to your contacts, or people could add people individually. What turns out, according to what was published, was that regardless of which of the three you clicked on, they were still accessing your contact book, and they didn't tell you that. So it made it seem like you had a choice, and you didn't. So for that reason, they had a pretty significant fine.
I thought they were also scraping the data and storing it on their servers too.
Yes, yeah. So they committed a whole host of sins, right? So it's a classic example of what not to do. Yes.
On the point of collecting content from children under 13, was that occurring contrary to something in the terms and conditions? For example, you, by using the application, you are stating that you're above 13, but they weren't above 13, and thus data was collected. Was it that type of issue, or was there not clear terms and conditions that stated that you had to be over 13 to be able to use it in the first place?
So there's two different issues there. One is, regardless of what you put in your terms of service, right, under COPPA, you cannot collect information from kids, certain information from kids, without verifiable parental consent, regardless of what your policy is, right? That's just, you just can't do it. And what they were doing, they were collecting either age or emails, like when you initially went and signed up. So it was even before, I think you kind of finished the registration, they were collecting information before they even knew whether they're dealing with kids or not. So that was one of the issues. But you can't get rid of through terms of service and disclosure. That's the kids protection is, that part is kind of mandated by the FTC.
So it leads into, I think, something else that I think we're going to talk about is, in this mobile world where you have devices that are used by adults and by children, let's say that an adult loads onto their device an application that doesn't have these types of constraints, and a child happens to use it half of the day and is interacting with it, and therefore content goes in from the child that is not being tracked. Can you talk about that minefield there, or is there a minefield?
Yeah, so on that, there's a difference there. If a parent registers for a service, right, and you know it's an adult, for example, if they choose to let their kids use that app, that's one thing. The COPPA typically goes to, and that's kind of a parental supervision type issue for the most part, because they created the account, they created the registration there. But if a kid is registering, or that's where you need to get the verifiable parental consent to before you collect the information. So let's take a look at, maybe Chris, you want to talk a little bit. You have the trifecta of issues. You have the general privacy issues, you have kids, and you have mobile. And one of the things I'll just kind of tee up and let Chris talk about a little more is that with mobile, there's an additional challenge in that we have limited screen space and the ability to do clear and conspicuous notices, whatever that means under the FTC, is even more challenging just because it's just of all the inherent limitations. So why don't you talk just from a practical business perspective? I'm sure you've thought a lot about these legal issues. How do you deal with these issues?
Yeah, so from my perspective, the FTC has really clamped down early on mobile compared to the web. So they were clearly unhappy with how the web has evolved and how easy it is for kids to share private information just by putting in their own email address and then ticking, yes, this is, I am an adult and my child can play this game. So on mobile, for example, even knowing the password to access the parent's credit card on the device is not a high enough standard for COPA. They then want an additional form of verification which requires some kind of knowledge that it's assumed that a child would not understand. So the parental consent is certainly a lot higher, and also, as you said, the ability to store any kind of data on the server, including IP address, which is would take a lot of work to try and make that identifiable data, but all of that needs to be discarded. And we have the additional complication because we enable chat. We need to keep a log for 7 years. If something does go bad, we can go to our log and say, yes, the kid was talking to somebody, and this is where it could have gone wrong. So you kind of, on one side, you need to not store any of the data, and then on the other side, you need to have a record.
Right. So one other thing I'll just mention from a privacy perspective is that when you deal with privacy information, sometimes there's a misunderstanding of what privacy is and what information is subject to that. So there has been cases and indications from the FTC that even things like the UDID of your mobile device and location information, particularly with kids, are deemed to be privacy-related elements. So some people think if you're not just collecting an email address, or you don't know a kid's actual name, that you're okay. That's not the case. So that's, I don't know, how do you guys do you address that, or?
We avoid collecting anything that we don't need.
Yeah. Right. So that's part of it. In the FTC, their other kind of general guidance is collect only what you need and keep it only for as long as you need it. Right. And again, that's the ideal state, not from a business perspective, but from a legal perspective. Obviously, there's a lot of value in the data and mining it over time, and businesses are doing that in a lot of different ways. But again, that kind of creates a tension with what the FTC wants to see, other than keeping things for regulatory verification.
So I'm curious, how many folks here are game developers? 4? Okay. And everyone else, are you here because you're interested in gamification, or?
I heard you were speaking. So.
I know that's why you're here, but.
Well, I have a question in that regard. I'm in an unusual situation in that I'm doing a lot of work right now with people overseas. And one of the things that we're building a kind of a platform. Justin knows a little bit, but I've never really explained it to him. We're building a platform that is primarily a business platform that has gamification. And people in other countries want to put their games into the gamification element to be shown on the web, really on the cloud, right? And they're doing a lot of work in dynamic translation, all kinds of things. Okay, so that puts us in a position of, okay, how do we handle international law relative to this? And how do we handle supporting all these people that are eager to do things, that have great things they've done in their respective countries? They just want to put it up, they don't really care. But it's all, the part I'm interested in is the gamification part right now. And I'm leaving early next year to talk to some people in Europe about all this. We've been doing a lot of work. And it's not clear to me that the FTC dictates everything in the world. I know there's agreements, but I know Justin's talking.
There's different laws in different countries. In Europe, the privacy protections are more stringent than they are in the U.S. So, the short answer to your question, which is much easier for me to say than it is for you to comply with, is that you need to look at it on a country-by-country basis based on where the users are primarily, and or where you're handling data. It gets very complicated when you're dealing with multiple international jurisdictions.
Well, also, the information can be visible in other countries, you know, like there's strong Indian interest right now to be part of it, and so if they're putting up something and it goes to Poland, for example, which is one of my bigger involvements, you know, what happens legally to this issue?
Well, again, I mean, depending on where you're operating and where the users are, you have to comply with the laws of each of the relevant countries, is the short answer.
So I think from a business perspective, though, you don't want to be in all those countries at once, right? There's probably
Well,
some
that wasn't
carving
the
out
plan,
of
right.
groups of companies. Well, just because, I mean, this is a website or it's a mobile app? Which one is it?
It's a cloud app. It's
Okay,
a
so
platform.
just the user acquisition investment that you'll have to do. If you try and be in multiple places, it's going to cost you a lot more. So from a rollout strategy, you're going to have to be focused on a country or a group of countries first, and so that makes the legal side of it much easier because then you can focus on this is where my marketing strategy dollars is going into. This is where my users will be, and that's where you guys can sort of work together on the legal implications.
Yeah, the problem that this is just verbal right now, but I've already been approached. They said, well, we really want to put up our stuff, and we're working on this translation tools and stuff, so we want to access the U.S. market from our stuff.
Yeah, and I think that was the point, right? If you're incorporated in the U.S. and your users are U.S., even if the creators are from another part of the world, in most cases, you're covering the U.S. laws is enough?
Well,
Is that
if
it?
it's just creators, it's really fact specific. Happy to talk to you about it some more afterwards so we can kind of keep this more general. But I think the general point for everybody is that when you are on an international arena, you just have to deal with laws in different countries. And you know, what applies when, you know, it depends on whether it's users or people just posting content to your site, what information you're collecting, what you're sharing. All of that can be relevant, but the laws do vary by country. There's no single, you know, you can comply with the U.S., but you may not be complying with Europe because it's more stringent, for example. So let's move on maybe to another topic.